Apparently there's like new court filings. Oh, it's by Andrew Brettler. Introduction. On November 5th, 2025, Magistrate Judge Torres ordered plaintiff to explain why a timely motion for protective order was not filed when knowledge of a dispute materialized. And to demonstrate good cause, nunc pro tunc, I guess, I don't know what that means, to excuse plaintiff's non-attendance at her deposition. Plaintiff's opposition does neither. Rather than move for a protective order as required under Federal Rule of Civil Procedure, plaintiff contends after the fact that she should not have been required to appear in Miami for a deposition, as doing so would have conflicted with her university classes, ridiculous by the way, and she would incur travel expenses. These excuses fall far below. Okay. Indeed, plaintiff fails altogether to explain her refusal to move for a protective order in the first instance. During the parties' meet and confer efforts, plaintiff's counsel expressly stated that they will not waste court time or plaintiff's resources by seeking such relief. Plaintiff's failure to seek a protective order warrants sanctions. Plaintiff's refusal to cooperate in rescheduling her deposition left her with just two options. Appear for her duly noticed deposition, which she filed with the court, right? Or two, seek a protective order, which, yeah, she did neither, I guess. The Federal Rules of Civil Procedure impose a bright line requirement. A party who objects to the timing or manner of a duly noticed deposition must seek a protective order, and a deponent's unilateral refusal to attend is improper. A party's failure to appear for a duly noticed deposition is not excused, unless the party failing to act has a pending motion for a protective order under Rule 26C. Courts within the circuit apply this rule strictly, okay? So precedents, right? Simply took it upon herself to ignore her discovery obligations, right? Plaintiffs recalcitrance. Your classes, listen, okay? Your bitch-ass classes can wait, okay? Your stupid fucking retard gay and retarded classes can wait, okay? Chill. Even if she genuinely believed she had scheduling... Oh, fuck. Oh, no! The law required her to seek protective relief. I didn't know you could highlight. That's so fucking cool. Oh my god, that's so cool. What? Oh my god, you can draw! Oh my god! Bro. Oh my god. I'm like a child again. Oh, you can do it in blue as well? Oh my god, that's so cool. Sorry. Sit for a duly noticed deposition unless otherwise excused. In her opposition, plaintiffs feigned reliance on Iguana versus Lanham provides her no refuge. As already noticed, Iguana does not stand for deposition. And even if, on its own terms, Iguana involved materially different circumstances, there the deposition date has never been finalized. Multiple alternative dates were offered, and the noticing party refused to adjust the witness's deposition date, even though every other participant was attempting to accommodate scheduling. Here, by contrast, plaintiff received a firm, timely deposition. Okay. Similarly, one of plaintiff's two lawyers asserted after the fact that the noticed November 3rd deposition was not a viable option because he needed to travel for a medical appointment. Okay. This belated excuse is of no consequence. Oh my god. Oh, yikes. First, the plaintiff is represented by two sets of lawyers, only one of whom allegedly was available on November 3rd. Second, plaintiff's counsel never disclosed this information, even if he did, blah, blah, blah. Regardless, plaintiff lacks good cause justifying her failure. Good cause, meaning not your fucking classes. Plaintiff could have traveled to Miami over the weekend without attending any class, and although plaintiff seemingly refused to indicate where she is studying, a cursory review of flights from multiple Illinois airports confirms numerous return flights. Oh my god, she could have taken after a deposit, limiting her absence to a single day. RIP. True. Yikes. Uh-oh. Uh-oh, somebody did their Illinois flight research. Who did it? Andrew Brettler, because only Andrew Brettler could have done it. Or was it, or could it be Destiny? Or maybe Destiny could have done it, and like he could have done that shit, right? Furthermore, that plaintiff preferred to sit for her deposition. Oh, what if that was like the research that he was doing last night? What if that was the shit that he was doing? Witness figured plaintiff's preference to be deposed during Thanksgiving break does not excuse her non-appearance at her deposition. To be clear, plaintiff filed suit in this forum in her paltry offering. Paltry offering! Oh my god. Limited to Thanksgiving week, as she would appear for an in-person deposition, the governing law is unequivocal. Plaintiff must make themselves available for examination. Yeah. Blah, blah, blah. Cyrus obligated by law. Uh-oh, illegal alert. Criminal, lock her up. Hashtag lock her up, okay? Pixie for prison 2016. Courts in this circuit consistently reject cost of travel arguments as a basis for non-appearance. Yikes! You don't even know your court. You don't even know your precedent, losers. Okay. Moreover, plaintiff failed to meet and confer in good faith. In her opposition, plaintiff falsely asserts that she offered multiple reasonable in-person dates for her deposition. In reality, plaintiff insisted she was unavailable for any in-person deposition for an entire month of November. Non-compliant alternative is not cooperation and does not excuse her refusal to appear on November 3rd. I'm assuming that all of this stuff is going to be brought up in the trial, if we're going to trial, right? Like assuming that the judge does not like dismiss the lawsuit due to the motion to dismiss, I'm assuming that this is going to trial, and this is like all the stuff that's gonna be brought up at trial, right? To be very clear, again, last minute evidence and reveals isn't really a thing, right? Because in actuality, the way that most court cases work is that all of these filings and all of the evidence and all the shit is gathered beforehand, right? It's gathered in filings and motions and shit like that. Yeah, like I'm assuming that all that shit is done beforehand, so the judge knows exactly what's coming. Everybody knows exactly what's coming. So in order to prepare yourself for court, you have to like use the information that's already been provided, because I feel as though the court would not look favorably upon like new information being presented in the middle of the trial, right? Like they would be like, bro, we never had any time to review this. We never had any time to look at this. So obviously we have to take it with a grain of salt, right? Any kind of new information that's being presented. There, the plaintiff insisted that she could not appear for deposition in the court forum district due to work obligations, childcare issues, and travel burdens. What? Childcare issues? Oh, sorry, Melvin. This is the different case. Okay, different case. Okay, I was like, what the fuck? Anyway, plaintiff's reliance on Chavez and Cherokee is misplaced. In Chavez, the court found the noticing party acted improperly by scheduling deposition. Here, plaintiff was in Illinois, not abroad, had more than a month of notice, and never offered competent evidence that she could not travel. Plaintiff also made no effort to accommodate the calendars of opposing lawyers. Okay. Instead, it insisted she would only appear during Thanksgiving break. This is gay. Yeah, this is gay. Plaintiff's recalcitrance has forced Bunnell to incur significant, albeit avoidable, legal fees and costs. Uh-oh. Andrew Bretler is like, bro, you know what's going on? You know what's going on, Steven? I think you're paying me too much, okay? You're paying me too much for this bad faith shit, okay? Bro, if it weren't for your lawsuit, I would have covered 50 trillion other lawsuits by now, okay? Plaintiff's refusal to uphold her discovery. Again, I have to say, it's always good for lawyers to like have a continued cooperation with their client. It's always good money, okay? Objectively speaking, it's always good money. But just keep in mind that at the same time, there are other cases that they are turning down because they don't have the time to cover that many cases. If a lawyer takes on every single possible case, then they're unable to win. They're unable to do the best work that they are supposed to do, right? Then they are overbooked. So just keep in mind that, yeah, even though they earn the money, it's not exactly like it's somewhat of a waste of time to handle bad faith like fucking lawsuits like this one. Yeah, especially, and you have to see it through to the end, right? Because for your own reputation and for your own career advancement and for your own name, right? I don't know. Yeah. Do you wonder if Andrew is starting to take the case personally because of how shitty the plaintiff's lawyers are acting? I think that if you're an experienced lawyer, I think at some point you become like really used to everything and you're just not really surprised by anything anymore. And you kind of learn to be more stoic at some point. Yeah. Like at some point you're just more stoic and you just don't really care anymore, I'm guessing. Because yeah, just so you know. Okay. Plaintiff's refusal to uphold her discovery obligations has resulted in significant legal fees and costs to Bunnell, all of which could have been avoided. Counsel for Bunnell spent significant time and resources preparing for the deposition, traveling across the country and scheduling a court reporter. Yeah, oh my god. That is a lot of like stupid hassle that Steven has to go through. Bernal has been forced to expend significant additional legal fees in bringing the instant motion. Now, in an attempt to avoid responsibility for the significant costs incurred by Bernal's counsel in traveling to Florida and preparing for a deposition, plaintiff contends that counsel for Bernal was already in Miami for another matter during the week of November 3rd, 2025. Plaintiff's assertion is false. I think by now he could have already spent... God, what did he tell me at the time? Did he say like $150,000 or is it $250,000? I think at this point he has spent like easily $250,000, if not like a little bit less than that, right? Or $200,000. Anyway, the only reason counsel for Bernal traveled to Miami during the week of November 3rd, 2025 was for the party depositions notice in this case. Plaintiff's counsel cites to an email undersigned counsel sent on September 22nd, in which the undersigned referred to having a court hearing in another matter on November 4th. At the time the undersigned sent that email, the undersigned had a video teleconference hearing scheduled on November 4th. Okay. Conclusion. Okay, let's go. For the reasons stated herein, Bernal respectfully requests that the court issue a protective order directing that the depositions of plaintiff and defendant be conducted during the same week, preferably November 24th and 25th. That's like 7 days and 8 days, respectively, in Miami, Florida. Right, so Bernal is asking pxie to appear in person in Florida. Absolute cinema. Bernal further respectfully requests that the court award Bernal his reasonable attorney's fees and costs incurred in bringing this instant motion. Okay, yeah. Cool. This is as gay and retarded as it can be, I guess. Hopefully this lawsuit gets dismissed, because fuck this lawsuit, and fuck everyone who's in it, okay? Except for Destiny. Actually, nah. Destiny is also retarded, okay? It's okay. He's not malicious.